Well, good morning, everyone, and welcome to the Issachar Foundation Jamaica, our public lecture series. My name is Philippa Davies, a member of the Issachar Foundation Jamaica and moderator for this morning's discussion on the topic of comparative jurisprudence of the Privy Council and the Caribbean Court of Justice beyond the Savings Law Clause. If this is your first Issachar Foundation Jamaica lecture, a warm welcome to you wherever you're joining, whether in Jamaica, the Caribbean, or across the world. This lecture series provides a discussion forum to explore public policy issues and social trends within the context of the Judeo-Christian worldview, which the Issachar Foundation Jamaica unabashedly affirms as the soundest foundation for nation building and human flourishing for everyone. We take our inspiration from the scriptures, First Chronicles chapter 12, verse 32, which says, "The men of Issachar understood the times and knew what Israel should do." Now, the Issachar Foundation Jamaica, we've hosted public lectures since August 2010. That's what, 15 years. Wow. And before COVID-19, we met in person. But since June 2020, the lectures have been online, and this is our 16th virtual lecture. Some of the previous topics are moral inputs, mortal outcomes, bridging the gap between values and crime, uncovering the hidden facts about NIDS, the National ID System, life with COVID, health, law, and liberty, weeding the family tree, the generational impact of ganja on the brain, keep us free from evil powers, an expose on the new ACP-EU agreement, it's now called the Samoa Agreement, combating state corruption 101, George Soros, globalism and the threat to human rights, and two is better than too many is leaving Jamaica with too few. These are just a few of the topics that we've looked at, and I invite you to visit the Issachar Foundation Jamaica YouTube channel to like, to subscribe, and to view the previous lectures. Now, if you somehow got invitation today because you were not on our mailing list, but you would like to be added to our mailing list so you can be informed of upcoming lectures, please post your email address in the chat. With the email address, I will then add it to our mailing list. At this time, I'm going to invite our chairman, Dr. Wayne West, to give his opening remarks and to open our session in prayer. Dr. Wayne West, you have the floor.
Not hearing your brother, Wayne.
Okay, I'm not quite sure why. Let us see. Yes. Can you hear me now? Are you hearing me now?
We can
Yes,
hear
we
you,
are.
but we can't see you. Okay, we can see you both now and hear you.
And good morning, Mrs. Davis. Thank you very much for your opening comments and for moderating our sessions as usual. You know, a worldview is the most important thing in terms of our thinking, because everyone has a worldview. It's a lens by which we examine the world, evaluate the world, and make decisions. And the Issachar Foundation came out of some sessions we had looking at a book called The Universe Next Door. The author is by the name of Siri, S-I-R-E. And it showed you that you can be sitting right next to persons that are in church, for example, and they have radically different worldviews. They see the world entirely different from the way you see it. And the biblical worldview is the only true worldview. We believe that really this should be something that all persons, including our children from an early age, should begin to understand and be exposed to. And this is why we have been doing this series and why we seek to inform people to know their worldviews and to evaluate the worldview they have, which is from the perspective of the biblical worldview, which is the only true worldview. So let us pray. Father, we thank you again that your word, Jesus said in John 18:37, when Pontius Pilate asked him, what is truth? And he said in John 18:37 that he came to testify to truth, because truth is the most important thing. Everything else is a lie, and it is destructive and the cause of the sufferings that we have. And in fact, in your kingdom, the thing that you will be establishing is truth. So Lord, we We know that in the Jamaican anthem, they said that truth be ours forever. So we pray that as we seek to bring truth to the issues of our courts, how should courts behave? What is the truth about how courts should make their decisions? That we will do so in a manner that is worthy of your calling, all for your honor, all for your glory. We pray in Jesus' name. Amen and amen.
Thank you very much, Dr. West, and to those who have joined. Since I said welcome earlier, welcome, and thanks so much for coming to this morning's 16th virtual lecture for the Issachar Foundation Jamaica. So glad to have you. Now, just to let you know, you will be muted and your videos will be off for the entire duration of the lecture, but you can post comments in the comment section. And if you have questions, because we will have an opportunity for questions and answers at the end of the presentations, you can send them to me, Philippa Davies, or Cheryl Pouchet, Pouchet. We will acknowledge them and relay them to our presenters. Now, today's discussion is part 2 of an expose on the differing approaches of the Privy Council and the Caribbean Court of Justice to issues of concern to us. This is to help us critically and thoughtfully consider which court is the better of the two as our apex or final court of appeal. Currently, our final court of appeal is the UK Privy Council, and there have been discussions over the years whether Jamaica should replace the Privy Council with the Caribbean Court of Justice as our final court of appeal. Now, the public debate on leaving the Privy Council is often presented to us through a narrow lens of geography and history. The Privy Council is in the UK, Caribbean Court of Justice is in the Caribbean. Or the Privy Council is part of our colonial heritage, whereas the CCJ, the Caribbean Court of Justice, represents independent maturity. But is it merely about geography or history, or is there more? Even weighty assessments to be made. And as our chairman said, worldviews matter in law and the decisions of the interpretation of laws that govern our lives. In part 1 of this discussion, which was held in May, our speakers were Mrs. Shirley Richards and Ms. Jamila Thomas, and they compared approaches of the CCJ and the Privy Council to the interpretation of savings law clauses based on the rulings of a few cases. Now, savings law clauses are clauses within the Charter of Rights of the Constitution which preserve the validity of certain laws and gives them immunity from judicial challenge. So under the Jamaican Constitution, our Charter of Rights contains several saving law clauses, including a clause to save punishment, which was lawful prior to the Charter, so the death penalty, saves the definition of marriage, being one man, one woman. It saves the law against buggery. It saves the law protecting the life of the unborn, and it saves the law against obscene publications. Mrs. Richards had looked at the CCJ's approach in 2 2018 cases from Barbados, Nervais and Severin on the mandatory nature of the death penalty, and a case from Guyana, McEwen, which looked at the legality of the law which prevented cross-dressing. And the CCJ in both cases commented that savings law clauses were colonial laws caught in a time warp, continue to exist in their primeval form, immune to the evolving understandings and effects of applicable fundamental rights. And in the CCJ's view, the savings law clause should be construed narrowly, that is restrictively, and should be subject to basic underlying principles of the rule of law and not what is written in black and white in the Constitution itself. Jamila then looked at 2 cases from Trinidad that went to the Privy Council because Trinidad still has a Privy Council as its final court of appeal. And that case, Chandler, looked also on the mandatory death penalty, whether it's constitutional, and Maharaj looked at the Sedition Act of 1920. The Privy Council rejected the CCJ's reasonings in Nervais and McEwen and said, as the text of a constitution is a living instrument, judges in performing that task may have to re-examine periodically the application of the provisions of a constitution to contemporary life. But Not all provisions in our Constitution allow themselves to be adapted to changing attitudes and changes in society, as the broadly worded statements of fundamental rights do. Some provisions are concrete and specific, and the Savings Law Clause that protects existing laws is one such provision, end of quote. So the Privy Council respected and upheld the Savings Law Clause compared to the CCJ, which expressed clear contempt and refused to apply it. Today, we'll be hearing another two speakers on the focus of comparative jurisprudence of the Privy Council and the Caribbean Court of Justice. Both our speakers are partners in the litigation department at the law firm Myers, Fletcher & Gordon in Kingston, Jamaica. Mrs. Alexi Robinson has represented clients successfully at all levels of Jamaica's court system, including at the Privy Council. Her practice areas include all aspects of general civil litigation, including property, family law, commercial and banking litigation, civil fraud, and judicial review. Mr. Matthew Royal specializes in employment law, intellectual property litigation, mediation and arbitration, public law, and real property. Please let us make welcome Alexis and Matthew, and we look forward to their presentations. Thank you.
Good morning, everyone, and may we consider all protocols observed. Thank you for choosing to be here this morning, and thank you to the Issachar Foundation for inviting us to speak on this important topic. If you give me a moment, I will try to share my screen. Hopefully get to see my presentation. Is everybody seeing my presentation?
Yes, we can see it. Thanks.
Great. Right. So I think that regardless of where we stand on this or in this debate, I hope that we can all agree that behind the impassioned cries to adopt the Caribbean Court of Justice as Jamaica's final appellate court is a deep yearning for independence, as Philippa said, or as I have put it in my paper, national sovereignty. Just a few weeks ago, the title of a letter to the editor jumped out at me. It said, Privy Council versus CCJ is a matter of self-belief. The author said the debate over the Privy Council versus the Caribbean Court of Justice is not just about legal quality, it is about our confidence as a nation. Indeed, much of the rhetoric surrounding the debate centers on nationalism, pride, and an understandable desire to throw off all vestiges of colonialism. We want to see and feel that we are truly and fully self-governed. In the letter, quality was understood as standards that can be built in our own institutions, and that therefore to reject the CCJ on that basis, instead of believing that we can match those standards, is damaging to our very selves and representative of a lingering colonial mindset. Oh, that it were so easy. If all we needed to do was choose to govern ourselves and take full ownership of our justice system, the decision would be obvious and uncomplicated. I doubt there's a Jamaican alive who would not choose self-government, self-sovereignty as a nation. But we're not speaking about the difference between owning our justice system or not. Both the Privy Council and the Caribbean Court of Justice amount to outsourcing our highest court. We could simply abolish appeals to the Privy Council and carry on with our remaining court system, which already has 5 levels. But that's not what's on the table. In fact, in 2004, when the government purported to abolish the right of appeal to the Privy Council and substitute a right of appeal to the CCJ, the Privy Council considered severing the striking out of the legislation to abolish from that to substitute, which would have left Jamaica with the Court of Appeal as the highest court in the land. In the end, though, the Privy Council struck down all of the legislation, preserving the status quo, noting that the then Solicitor General expressly declined to challenge the conclusions that had led them to that decision. It almost seems to be implicitly understood that something is required above the Court of Appeal. Central to that 2004 case was a concern about the independence of the CCJ judges, which the Privy Council held was all but universally recognized as a necessary feature of the rule of law. How the CCJ achieves the independence of its judges is therefore of extreme importance, and if their independence can be called into question, then any idea that choosing the CCJ for Jamaica is about sovereignty is obviously not in fact the case. Irrespective of whether it is a lingering colonial mindset or the zeal to be free of it, or something else entirely, it seems that many today are blinded from seeing the current space of neocolonialism that binds us to globalizing institutions incapable of serving our democratically determined interests. Our ancestors fought hard for us to have government of the people, by the people, for the people. As a free and democratic nation, we must denounce neocolonialism with as much gusto as its predecessor and ensure that we do not unwillingly fall prey to the coup of globalizing institutions, leading us all down one gilded road paved with good intentions, but refusing to hear us democratically on what matters most. In this context, quality cannot be taken to just be a reference to standards, like the time that it takes for a court to deliver a judgment, for instance. We can build those things into our own institutions. Of course we can. I cannot believe anyone could seriously believe 62 years post-independence that we can't. Jamaica has so much to be proud of, as demonstrated in the largely free and fair high-stakes elections that were smoothly held on Wednesday. The quality of a court's jurisprudence is critical to its ability to dispense justice and is underpinned by the philosophies and principles of the judges themselves. If philosophies and principles alien to our ethos as a nation are the foundation of the jurisprudence, the court's decisions will not, in fact, result in sovereignty for Jamaicans. The very opposite could be true. The court's decisions could become our firmest shackles yet. With this in mind, this debate cannot be had without a serious look at the quality of the jurisprudence of the Privy Council versus the CCJ. Today, my intention is to contribute to this debate by highlighting a few cases that demonstrate some crucial differences in the jurisprudence of these two courts. You can then judge for yourselves which court will be the one that will secure or maintain Jamaica's sovereignty. In the recent case of 4 Women Scotland Limited against the Scottish ministers, the decision that confirmed that woman in the Equality Act of 2010 in fact refers to a biological woman, the judges of the Privy Council, who were impaneled as the UK Supreme Court, helpfully observed that citizens, with the assistance of their advisors, are intended to be able to understand parliamentary enactments so that they can regulate their conduct accordingly. They should be able to rely upon what they read in an act of parliament. They reiterated some pretty foundational principles of statutory interpretation, such as that anything external to the legislation is just a guide to interpretation, giving context only, and cannot displace the clear and unambiguous meanings conveyed by words in a statute which do not produce absurdity. The judges were clear that their duty is to objectively assess the meaning a reasonable legislature would seek to convey in using the statutory words under consideration, and that the best way of doing so would be to give a meaning that is constant and predictable, achieved by construing words according to the ordinary meaning of the words used. The presumption that a word has the same meaning throughout the act when used more than once in the same statute is consistent with this principle. Accordingly, they overturned an earlier ruling that suggested that it would be possible to have woman mean 2 different things in the same act, depending on the context. This was going to be required if a transsex definition could be workable, because the act had provisions related to pregnancy and maternity, clear matters of fact and biology. The judges of the Privy Council, impaneled as the UK Supreme Court, pointed out in response, by its nature, a variable definition is neither clear, constant, nor predictable. It is the opposite, in fact. Individuals and organizations required to apply the act in practice should not have to work out which of the variable definitions apply without assistance from the words of the legislation itself. In so doing, they affirmed that to otherwise define woman to include a sex that had been certified, but that was not biological fact, would lead to incoherence and absurdity in the practical operation of the Equality Act of 2010. So words mean what they say and should be interpreted in that way. Otherwise, absurdities can result. I hope you can agree with me that this is necessary for having a stable society in which we can operate with some amount of assurance that things will be the way they in fact are. The sky is blue, but now it seems we need judicial decisions to confirm these basic things to us. This is to be contrasted with a recent decision of the CCJ, in which reference was made to the CCJ's task to play a determinative role in the further development of Caribbean jurisprudence through the judicial process. To justify its approach to the interpretation of Caribbean social justice legislation, which, it says, requires permissiveness. The CCJ pointed out that this requires not just the traditional mindset set out above by the Privy Council that I just referred to in the For Women judgment, but also requires interpretation through constitutional values and right-centric lenses, including preambular values and principles filtered through the relevant Caribbean social contexts. The majority opinion champions a first principles methodological approach, meaning that it is informed yet unburdened by precedent, so that it looks through and interprets constitutional and legislative language and purpose to achieve stated and aspirational goals in practical and legislatively legitimate ways. The legislation should, when appropriate, be interpreted and applied purposively, teleologically, and generously, so as to give the fullest remedial protection to the intended beneficiaries. When faced with multiple choices of meaning, a consequentialist policy analysis is applied, and the interpretation that most aligns with discovered statutory intent and values is to be preferred. So those are the guiding principles that the CCJ had set out in this case, the case of CGI Consumers Guarantee Insurance Company Limited versus Stevenson and Thomas. Some facts of the case are that on November 29, 2007, Mr. Stevenson accidentally hit and killed a pedestrian, Ms. Thomas. At the time of the accident, there was a current policy of insurance in respect of the vehicle involved, but Mr. Stevenson's driver's license had expired on 30th of June 2007, several months before, and remained expired until the first working day after the accident, when he renewed it by paying the necessary renewal fee. Ms. Thomas's estate in November of 2010, so 3 years later, commenced an action against Mr. Stevenson. And on March 31, 2023, 13 years after it started and 16 years after the accident, her estate obtained judgment. Prior to that, so prior to even the commencement of the action by her estate, the insurance company had brought separate proceedings for declarations that it was not liable to indemnify Mr. Stevenson on the basis that the accident was not covered by the policy. This was because the policy specifically excluded coverage if the driver does not hold or is disqualified from holding or obtaining a valid driver's license. Recall that Mr. Stevenson's driver's license had expired in the June of the year that the accident happened, and the accident happened in November. So he did not have a driver's license at the time of the accident. The key provision of, the key statutory provision that was interpreted by the court was Section 43(1) of the Barbados Road Traffic Act, which the court, in its own judgment, said grants freedom to the parties to an insurance contract to determine the terms excluding liability under the policy. That clause reads, where after a certificate of insurance has been issued in favor of the person by whom a policy has been effected, judgment in respect of any liability required to be covered by a policy, being a liability covered by the terms of the policy, is obtained against any person insured by the policy, then, notwithstanding that the insurer may be entitled to avoid or cancel, or may have avoided or canceled the policy, the insurer shall pay to the persons entitled to the benefit of the judgment any sum payable thereunder in respect of the liability. The legislation, So the CCJ looked at this provision and considered that it was permissible to both read in or read down words in the section, a permission for teleological modification. A majority of the judges did this, rendering the words in parentheses, which I'll go back to, they're in bold, being a liability covered by the terms of the policy, as, the decision by the judges rendered those words useless by limiting them to references to liabilities covered by the policy at inception and not at the time of the incident giving rise to the claim. They held that to construe them otherwise would have been irrational. Now, this is particularly interesting to consider because the first two decisions below the CCJ had also made the insurance company liable. And in the CCJ's review of those decisions, they had pointed out that the orthodox view has long been that the words in brackets, those same words that are in brackets on the screen, enable parties to exclude liability under the policy provided that the exclusion clause was not unreasonable or unfair and did not fall within the restrictions specifically imposed by the Act. The insurance industry in Barbados and in much of the Caribbean has been based upon this understanding. It has already been seen that the judicial finding that the exclusion clause in this case was not unreasonable or unfair under the Consumer Protection Act was not appealed to this court. So there is no issue here that it's clear that the industry understands these words and has been based on this for many years. There's no issue here that the exclusion clause was unreasonable or unfair. However, the court still decided to find that it did not apply. The not only was the Caribbean Court of Justice aware of the fact that the ordinary interpretation of this language had been that way, they also spoke to the fact that the weight of Caribbean authorities was decisively in favor of the view that Section 43 on the screen allows an insurer to limit its liability to third parties. And they referred to a number of Caribbean cases. Specifically, they referenced the view of automatic insurance in Matadine had been rejected in a case called Willis by Justice of Appeal Panton in Jamaica. And they referred to Justice of Appeal Phillips' emphatic statement that it would be wrong to impose on an insurer a liability that the insurance policy did not purport to cover, and that in order for the third party to benefit from the indemnity provided, the liability must be one that is covered by the insurance policy. The availability of the contractual defense had led our Justice of Appeal Phillips, or our then Justice of Appeal Phillips, to issue the following impassioned call, and the CCJ repeated the call in its judgment. And I'm going to read a little bit of it. It says, the injuries suffered by the appellant are serious and substantial, and it is most unfortunate that no facility exists in Jamaica to satisfy the judgment in this claim. The Privy Council has highlighted the step taken by Great Britain's legislature to protect innocent third parties from the actions of uninsured drivers, with the creation of the Motor Insurers Bureau Compensation of Victims of Uninsured Drivers Agreement. This agreement provides that if judgment in respect of any relevant liability is obtained against any person in any court in Great Britain, whether or not the person is covered by a contract of insurance and any such judgment is not satisfied in full within 7 days, the Bureau will pay or cause to be paid the said sums in full with costs. While I recognize that unfortunately there is no institution of this type in Jamaica, the Jamaican legislature ought to take the crucial and novel step of being the first in the region to implement such a scheme in order to cure the social evil created when unlicensed drivers cause personal injury, property damage, or death to innocent third parties for which there is no compensation. The CCJ highlighted that this recommendation remains as relevant today as when it was issued a decade ago, and one that is worthy of consideration by all Caribbean legislatures. The fact remains, however, the CCJ said, when looking at the decisions that had been made below, that existing legislation which expressly permits insurers to contractually exclude liability should not be ignored or interpreted by the court to impose essentially compulsory insurance, filling the gap created by the absence of an institution equivalent to the Motor Insurers Bureau of the United Kingdom. Neither can the problem be resolved by referring in general terms to public policy considerations or to the purpose of the Act. In my view, and this was Justice Anderson of the CCJ, the public policy considerations cited cannot override the express terms in the statute. So in his review of the decisions below, he was quite critical of the fact that they had taken cognizance of the fact that this was a very unfortunate situation. A lady had died, her estate needed to be compensated, but that should not be enough to read words that aren't there in, or to say things that are just manifestly not justifiable on the terms of the contract or the Act. He then went on to say that in his respectful view, it follows that under Section 43(1) on the screen, the exposure of the insurer is restricted to liability covered by the terms of the policy. And this means that a liability covered by the policy of insurance, or which would be covered but for the fact that the insurer is entitled to avoid or cancel, or has avoided or canceled the policy. This reinforces that the contractual defenses are available to the insurer. And that has been the way that these kinds of things have been understood for generations. The judgment then goes on to consider some of the restrictions that are in the Act, the Road Traffic Act, which does say that insurance companies cannot restrict coverage for unnecessary things, such as the age or physical condition of the persons driving, the condition of the vehicle, the number of persons that it is carrying, the weight or physical characteristics of goods, etc. So there are, in fact, some limitations on the exclusions that the insurance companies can put in place. And he then continues to point out that the exclusion clause was not rendered void by any of those restrictions in the Act, and therefore it was a good exclusion clause. He says it remains open to the Parliament of Barbados to adjust the statutory restrictions on exclusion terms that may be included in a motor vehicle insurance policy, even outside of those considered to be unfair or unreasonable under the Consumer Protection Act. So this all seems fairly normal and in line with what we have come to understand and appreciate from our courts. Then Justice Anderson goes into the question of whether the principle of contra preferentum is applicable in this case, because one of the judges below had used this as a reason for why the policy was going to be allowed to be upheld. And he says, the question arises as to whether there was ambiguity or obscurity in the wording of the exclusion clause, and if so, whether it is sufficient to apply the contra preferentum rule. And just for those who may not be attorneys here, the contra preferentum rule is a rule that has been in existence. I think it can be traced all the way back to the period of Roman law, and it's well established in insurance law. It's very customary for policies to be written and presented to the insured by the insurers. There's an imbalance of power. And so the courts have consistently held that it is the responsibility of the insurers to ensure that precision and clarity are attained in the wording of the policy terms. So any ambiguity that exists is going to be resolved by adopting the construction that is most favorable to the insured person, not to the insurance company. And so the judgment goes on to consider that rule and to criticize the judge below for finding that the contra preferentum principle applied, because there really had been, that judge had not really indicated that there was any ambiguity in the language, which is the only reason why contra preferentum would come into, would need to be applied. But interestingly, Justice Anderson then says that he's going to look again, though, at the whole issue of whether the rule applies. And he says, well, hold on, let me just first say that in the his criticism of the court below says, he says, the majority in the court below agreed that the permit holder whose permit expired does not commit the offense created, and that should be defeated because third-party rights are extinguished by the mere failure of a permit holder to renew his permit on his birthday. And the majority of the court below agreed with this view, which justified their construction of the exclusion clause as applying to persons who were unlicensed or disqualified from driving, but not to a licensed driver who fails or neglects to renew his license. So they had made a distinction between somebody who had never got their license before or had been disqualified for some reason and somebody who just failed to pay the renewal fee. And you'll remember in this case, Mr. Stevenson, his license expired in June and he paid the renewal fee the day after the accident. So he falls into this other category of people who, it's not that he never was licensed, it's just that it was a fee issue. But Justice Anderson says it's difficult to accept this framing of the issue by the Court of Appeal. Having affirmed the entitlement conferred by the Act upon the parties to include terms which entitle the insurer to avoid liability, it becomes difficult to insert restrictions which limit that entitlement to terms that are material to and circumscribe the risk undertaken by the insurer. And he rules that the contra preferentum rule cannot be invoked merely on the basis that the exclusion clause does not increase the physical risk to the insurer. He then goes on, however, to look at the definition of license in the Act, and it's there on the screen. License means a driving license or other permit issued by or on behalf of the licensing authority, which is valid and currently in force. I want to highlight for you that the exclusion clause had only mentioned that you needed to have a valid license. And so Justice Anderson rules that the introduction in the definition of license of it being currently in force brings ambiguity to the Act, and therefore, for that reason, the contra preferentum rule can be applied. And he then held that having itself made the distinction between a valid license and one that is currently in force, what the insurer cannot do is continue to accept or retain premium in respect of a period after the expiry of the policyholder's driver's license and then deny coverage, except on the clearest of grounds, and the exclusion extended to a driver's license that was not currently in force at the time that the risk was realized. And so the insurance company, after taking this case to the first court, the second court, and now the Caribbean Court of Justice, was held to have to indemnify Mr. Stevenson for the loss that he had caused to Ms. Thomas. At the end of the judgment, the majority decision, which was not by Anderson, the majority was Rajnoff, Lee, Barrow, and Jamadar. And they were the ones who had spoken to the need for this purposive and right-centric methodology of interpretation. At the end of their judgment, they point out that concerns expressed about increased insurance premiums, if this interpretation of Section 43 contained in this opinion is adopted, are speculative and an overreach of judicial function. In any event, as demonstrated in Hansard, Parliament was alive to this issue and nevertheless pursued its legislative policy. So they are aware of the fact that the Parliament knew what the concerns were, still allowed this exclusion clause, knew that the exclusion clause had been interpreted by the courts in a particular way for a very long time, and yet they still managed to change all of that, pointing to the fact that the legislative policy was what it was. The Parliament had indicated that these were the accepted ways in which risk was going to be allocated in these circumstances. And the Caribbean Court of Justice decided that they were going to do it otherwise. At the end of that majority judgment, there is this clause, or this statement, as is said colloquially for Parliament in passing this law, the juice is worth the squeeze. It is therefore not for the judiciary to second guess or unjustifiably circumscribe such a policy by limiting textual interpretations. In any event, the third-party statutory limits for compensation are prescribed and known, thus predictably insurable, and are no doubt already included in premiums as a matter of pragmatic insurance common sense. On the other hand, we could perhaps say, as we do in legal circles, that maybe hard cases make bad law. I will take you now to a Privy Council case that was decided in 2022 to Farai Morrison and the King against the Privy Council. I'm sorry, that's 2023. Here, the Jamaican appellant pleaded guilty to illegal possession of a firearm, robbery with aggravation, and wounding with intent to cause grievous bodily harm. He was 16 years old at the time of the offenses, and he was 17 at the time of sentence. The Privy Council acknowledged that the Child Care and Protection Act that was enacted in 2004, that was done to reflect Jamaica's ratification of the United Nations Convention on the Rights of a Child in 1991. The Privy Council also acknowledged that there was a deliberate decision taken by the government of Jamaica not to implement some of the terms of the convention, particularly given the different treatment of children aged 14 or older in respect of serious crimes. Mr. Morrison's counsel argued that although ratification of the UNCRC by Jamaica did not import its requirements into domestic law, the charter provision should be given a broad and purposive construction to achieve the same outcome. The Privy Council did not accept that submission, noting that the legislative history demonstrated the intention to omit those elements of the UNCRC from the CCPA, much like how the Barbados Act, the choices made by the Parliament had also demonstrated an intention to omit certain things from the insurance company's purview. The Privy Council held that unspecific and general words of the provision in the Charter was an unlikely vehicle to transport the detailed rights for which the appellant contends. And so in this case, although there was every potential opportunity for the Privy Council in support of a young teenager to get more preferential treatment on sentencing, they maintained their adherence to the text and left it for Parliament to make the changes that were being sought. I will take you to the CCJ case of Katrina Smith against Albert Anthony Selby, a 2017 decision of the Caribbean Court of Justice, to further illustrate the CCJ's approach to hard cases. Katrina was a single woman. The deceased, a man who was separated from his wife and officially divorced on the 30th of April 2004. Katrina and the deceased had lived together since April of 2002. He died suddenly in April of 2002 without a will. Katrina and the deceased were not married, they had no children, and he was predeceased by his parents. He was survived by his siblings, including Albert, and so they were in line to inherit equally if Katrina was not his spouse. If Katrina was declared his spouse, then she would get 2/3 of his estate, and 1/3 would go to his siblings to be shared equally. If she was not his spouse, she would not get anything. The court was looking at the Succession Act of Barbados, which defines spouse to include a single woman who was living together with a single man as his wife for a period of not less than 5 years, immediately preceding the date of his death. The court stated in its judgment that the issue before it was to determine whether Katrina was a spouse of the deceased, not to determine whether the Court of Appeal was wrong to say that she wasn't. And the question that it asked itself was whether the deceased was single. The court below, the first instance court had said, yes, she is the spouse because spouse includes a married man who is separated from his wife. And the Caribbean court, criticizing that decision, said that the trial judge had been influenced by his perception that the purpose of the statute was to correct the problem faced by the survivor of a non-marital relationship where there was no will. The Court of Appeal said that the trial judge had erred by distorting the ordinary and natural meaning of the word single by importing this idea of separation, and that the alternative conclusion that single was descriptive of status at the time of death was also incorrect. The CCJ having criticized both the trial judge and the Court of Appeal for their view of their permissive interpretation of the word single, the CCJ then said that the purpose of the act was to provide protection for the survivor of a cohabiting relationship, regardless of the marital status of the parties, and therefore the assessment of marital status for the purpose of rights under the act is to be made immediately preceding the death of the deceased and not for the duration of the cohabitation, despite the fact that in all judgments in the Caribbean that have looked at this definition of spouse, it has always been understood that the singleness of both parties is something that must be for the duration of the cohabitation. And to just give you a little bit more in relation to that, in that Succession Act in Barbados, there were some areas of the act where they did not look at the question of either singleness or cohabitation. So, for instance, where a person was cohabiting but not a spouse, if the deceased had been maintaining that person, then they were still entitled to benefit from the estate. And it was that section that the CCJ took to say meant that, that the purpose of the act generally was to provide for protection of survivors of cohabiting relationships, regardless of the marital status. But again, Parliament had already chosen how it was going to do that. And it had already circumscribed it to situations where the person cohabiting, the surviving cohabitor, was a dependent of the deceased. And what the CCJ did was to take that and lift it and put it onto the definition of spouse generally, to then open the gates wide for anybody who was a cohabitor to be allowed to benefit in that way. So I ask, Privy Council or Caribbean Court of Justice, is the juice worth the squeeze? Thank you.
Thank you very much, Alexi. And we will just go straight to Matthew, and then we will receive the questions and comments that our audience will have. So in the meanwhile, attendees, please do put your questions together to put into the chat, posting either to myself, Philippa Davies, or to Cheryl Pouchet. Matthew, over to you. Thanks.
Good morning, everyone. In October 2015, I gave a speech at the University of the West Indies Faculty of Law, offering full-throated support to Jamaica's adoption of the Caribbean Court of Justice as its final court of appeal. I was then at the start of my final year in the Faculty of Law and very confident about the many positions I passionately held on all and sundry social, political, and economic issues, as every 21-year-old seems to be. Needless to say, now, 10 years later, my views have evolved. And I know what you're thinking. Age and maturity has gotten the better of his youthful exuberance, and he has come to see the light. But I do not know that you would be correct in that position. Granted, I certainly have aged, the back pain has already set in, and I would like to consider myself as having noticeably matured over the passage of more than a decade. But I still agree with the positions held by the younger version of myself. There is heavy logic in support of the adoption of an Indigenous Caribbean Final Court of Appeal. The development of a Commonwealth Caribbean jurisprudence, informed by a deep understanding of local and regional realities, shared history, culture, and perspectives, is likely to enhance our development and application of law. The process of our independence and indeed emancipation is not complete while we still refer our most difficult questions of law to His Majesty the King in Council. And we are paying for the CCJ anyway. My present disagreement, however, and rest assured there is significant disagreement, with our adoption of the CCJ as our final court of appeal does not run contrary to those core ideals. I still hold to and agree with them. These ideals, however, cannot give way to the realities of the CCJ's operations throughout its north of 20 years since it has been a court of appeal. My concerns, apart from its treatment of savings law clauses and the other doubt-inspiring aspects of its jurisprudence covered by Alexei, extend to the following two areas. The first is the court's perception of its own role in our constitutional democracy. And the second is the principles espoused in its code of conducts, particularly around the issue of equality. If you would permit me, I will spend just a few minutes delving deeper into those two issues. The traditional zeitgeist concerning the role of common law judges is possibly most aptly captured in this statement by the now Chief Justice of the United States Supreme Court, Chief Justice John G. Roberts, which he expressed during his 2005 Senate confirmation hearings. Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. In this American folksy telling, Chief Justice Roberts articulates fundamental principles of our constitutional democratic order. Principles common to the United States Federalist constitutional model and the constitutions following the Westminster model, such as our own. It is the principle that judges are restrained in their role by the explicit text and explicit principles of our constitutions, which enshrines the doctrines of separations of power. These doctrines bestow lawmaking powers to a large body of people's representatives, answerable to an electorate through regular election cycles, and not to panels of life-tenured lawyers sitting in committees of 3, 5, or 9. The common law judge, duly regardful of his or her constitutional role and duties, further reduces their understanding of the broader mandates of separation of powers to the brief maxim, judicial restraint. Speaking on the importance of judicial restraint to our constitutional order, Lord Sumption, formerly a judge of the UK Supreme Court and the Judicial Committee of the Privy Council, noted in an August 9, 2022 interview given to John Anderson Media, after sharing personal comments on decisions of the United States Supreme Court concerning social issues, he observed that the way in which these things have been introduced to the polity of the United States was a serious mistake, because I think the legislative process can be an important influence in reconciling people to radical changes in social values. If it is imposed on them by a judicial body, I doubt that the process will be as smooth. The UK Supreme Court, whose judges staff the Judicial Committee of the Privy Council, has recently demonstrated their commitment to judicial restraint and their resistance to activist judicial reasoning and decision-making. As Alexei has mentioned before, in 4 Women Scotland Limited and Scottish Ministers, the court determined that the terms woman and sex, as used in the Equality Act 2010, refer to biological sex. My approval of this decision is not born merely from favor with the outcome. It is born from an endorsement of the judicial philosophy that underpinned the court's approach to the issues. At paragraph 2 of the court's written reasons, the court noted as follows: "It is not the role of the court to adjudicate on the arguments in the public domain on the meaning of gender or sex, nor is it to define the meaning of the word woman other than when it is used in the provisions of the Equality Act 2010. It has a more limited role, which does not involve making policy." This is the central ethos of the common law court, the court that views itself as a creature of its constitution, as a body who is limited by the other organs of government, and who understands that its role is not to exercise broad legislative powers, but to interpret and apply laws as they come before them. This approach of the UK Supreme Court and Privy Council can be contrasted with certain statements made in public by judges of the CCJ. And I make these observations and state these quotes quite apart from the actual judicial reasoning or conclusions in the judgments. I'm making particular observations of the approach of judges to the role of judging. Peter Jamadar, a judge of the CCJ, posted on LinkedIn in the judgment, the CCJ judgment in OO and BK and the Attorney General of Barbados. And his preamble to posting the judgment noted, "Today, the CCJ delivered a notable judgment. It confirmed a broad and purposive, right-centric and contextually sensitive interpretation and application of legislation to ensure the recognition and protection of all victim survivors of domestic violence. One more step in developing truly Caribbean jurisprudence." In a more extensive LinkedIn post, Judge Jamadar noted in an extract from Gulab Lalchand and Rutila Olivia Supal the following: "December 13, 2024, the CCJ delivered a landmark decision concerning cohabitational relationships and cohabitational agreements in Belizean case of Lechel and Supal. Legal intervention must be consonant not only with reason and palpable justice, but also with the culture and way of life of so many of our citizens." He went on to note that a majority of the court agreed with and adopted the application of social context and gender-sensitive approaches to the analysis of the relevant law and concluded certain things in the making of that judgment. If the traditional zeitgeist were to prevail, the public social media commentary by Judge Jamadar on his own judgments may be seen as descending into the arena, espousing a particular and limited viewpoint of the law, and betraying the necessary limitations of judicial restraint. There is little doubt that openly espousing and endorsing particular policy preferences is problematic. The language adopted by the CCJ in its own self-description as an apex court demonstrates its view as being part of the norm-forming organs of government, playing a role in shaping and directing Commonwealth Caribbean jurisprudence, but not jurisprudence alone, or values and or attitudes. The doctrines of separation of powers, and the principles of judicial restraint that it requires provide no accommodation for this perspective on the breadth of judicial power and the role that the judiciary in our constitutional order ought to play. Some light, however, might be shed on why judges take this approach or are free to publicize their views when certain provisions of the CCJ Code of Conduct is examined. Section 5 of the Code addresses issues of equality and provides the following few principles, which I will summarize. Firstly, judges shall strive to be aware of and to understand diversity in society and differences that are based on various grounds and arise from sources including but not limited to race, color, gender, gender identity, religion, national or geographic origin, culture, language, disability, age, marital status, sexual orientation, social and economic status, and other like grounds and sources. The code goes on to group these sources, as it is called, under the term irrelevant considerations. So all of these collectively form what the court regards as irrelevant considerations. And it goes on at 5.2 of the course to say that judges are required to not manifest bias or prejudice towards people on the basis of the irrelevant considerations. Clause 5.5 notes that CCJ judges are required to ensure that lawyers appearing before them do not manifest bias on the basis of irrelevant considerations, with a small proviso or exception for what it describes as legitimate advocacy. Judges of the CCJ are prohibited from membership in or association with society or organizations which practices or may reasonably be perceived as practicing invidious discrimination on the basis of any irrelevant consideration. That is 5.6 of the code. And lastly, judges are also admonished to be aware that discrimination on irrelevant considerations could be perpetuated in subtle and unintentional ways and requires its judges to be astute to take proactive measures to promote substantive equality and to proscribe such discrimination, whether perpetuated by lawyers, litigants, or court staff. A myriad of issues arises from these provisions. Firstly, despite this requirement being cleverly disguised in negative expressions, i.e., shall not manifest bias or prejudice on any irrelevant consideration, a fair construction of these provisions show a requirement, a positive requirement to at least determine matters in a way that is neutral to deeply held beliefs on issues such as gender identity, sexual orientation, and perhaps more perniciously, require judges to rule in a manner that is consistent with liberal values and attitudes toward these issues, thereby fulfilling the requirement not to manifest bias on the basis of these grounds. Even on the more lenient of the two interpretations, there is evidently a chilling effect on the independence that a judge or panel of judges hearing a matter must bring to bear on the determination of the issues before them. At the further extreme, it may be read as imposing an ideological homogeny which judges are required to bring to bear in their decision-making. Secondly, the mandate of judges to police the submissions of counsel before it gives way and gives rise to a similar chilling effect on the ability of counsel to effectively marshal arguments relating to sensitive issues. Yes, there is a proviso and exception for legitimate advocacy, but what constitutes legitimate advocacy? And why is legitimate advocacy to be determined by the judge hearing the matter generally? And when we consider the requirement for judges to proscribe discrimination when it is perpetuated by lawyers or litigants before them, it gives further cause for concern that the idea that advocacy points or arguments raised by judges may be scrutinized for verification of whether they fall under irrelevant considerations or legitimate advocacy gives rise to a further chilling effect on the ability of litigants appearing before this court to express their positions on very sensitive issues that are social in nature and has broad societal impact. The requirement of 5.6 is also particularly concerning, where judges are prohibited from membership in or association with societies which practices or may reasonably be perceived as practicing invidious discrimination on the basis of any irrelevant consideration. It is conceivable that a member of an organization which proudly and openly espouses Judeo-Christian worldviews, traditional views on marriage and the roles of men and women, may be prohibited from membership of a court such as the CCJ, therefore reinforcing this idea that there is an ideological hegemony to which the CCJ judges must commit to, reflect in their decision-making, reflect in their control of their courtroom, and in consideration of the outcome of cases before them. This, when viewed in the context of the public statements by judges of the CCJ, which celebrate and tout particular perspectives and ideologies, gives question as to whether this is a court that is committed to impartial, open, disciplined, and limited approaches to judicial reasoning and decision-making, approaches without which there can be little confidence in the integrity of our judicial process. So in considering whether we jump to the CCJ for all the values and virtues that having a local court do offer, we must consider whether the jurisprudence and ideology of the CCJ matches well with our own democratic realities and ideals. Thank you.
Well, thank you very much, Matthew, for your presentation and your honest disclosure and humble admission of evolved thinking with age. And certainly we appreciate your expression of patriotic leanings for our courts to be Caribbean through and through, all the way through. But as learned counsel, we welcome your affirmation of the importance of sound defensible reasoning by our judiciary and them observing the boundaries of power and what exactly are the different roles of the arms of government. So thank you very much. And indeed, just a comment on your exploration or your examination of the codes and what impact it would have. The irrelevancies are not irrelevant at all. They're quite relevant because it's a backdoor chilling effect on the pleadings that would be made and the rulings. And in fact, if it is the CCJ that would decide what is legitimate advocacy or what is not, it's as if they're exercising control of who will have access to the law courts as an apex court. And that could cause or trigger an injustice because you're denying access to those who hold a certain worldview. So thank you very much for your analysis and sharing of those thoughts. And Alexi, when you had quoted from some of the rulings, I heard some of the comments informed by be unburdened by precedent and social justice legislation, but did they define what social justice meant? And a consequentialist approach. It seems as if they would want to fix the outcome based on their perception of what would be a right decision, regardless or ignoring the law. I mean, just thinking about the case with Tafari Morrison, and you could see, a compassionate response. We would want to do this for a minor, but as the Privy Council ruled, as hard as it may seem, we've got to leave to Parliament what their role is. We've got to stick to the law. So it's not about fixing an outcome, because really that would then make all of us, anyone coming to the courts, very nervous and anxious, because it will depend on who you're getting on what day and how they feel about a particular case, the facts of the case, and not the law itself. And that would really render redundant going to law school, because it's up to the judges that you're meeting on that particular day. So thank you very much to our presenters, and we do have some questions. So Matthew, if you can come back on screen, I'm going to start with the questions and either of you can respond. So I think this one will go to Alexi because it has to do with the insurance company case. Was there any complaint or pushback by the insurance company or the insurance company's board in Barbados after the conclusion of that first case that you mentioned. What is the governing ethos of the CCJ? It seems to be or desires to be a moral arbiter as opposed to an interpreter of a nation's constitution. Alexia?
That's a very apt comment. Unfortunately, I can't say that I looked into the response in Barbados after this. In fact, this judgment just came out, so I'm pretty sure they're still sort of reeling from it. So it probably is unfolding even now, and I'm sure there's going to be some sort of maybe consultations with the parliament to see whether they can fix what has now been undone. But yeah, I don't know what it is. This judgment is about 2 weeks old.
All right, thank you so much that you're able to share it with us already. The cohabiting case, which country was it? I think it was Barbados as well.
It was also Barbados.
Okay, how exactly did the CCJ ruling contravene the intent of the legislature?
Okay, so in the cohabiting case, the statute had provided very clearly that definition of spouse is a pretty standard definition across Caribbean statutes, and it has been interpreted from its inception to mean that the 5 years of singleness and of living together is for the entire 5-year period, not just at the time of death. So it was a novel interpretation designed to give Katrina what everybody thought she was entitled to. But the way that they got there was very, it's brilliant, really, because there is a provision in the act that says that even if you're not for the 5 years, even if you're not married, so long as you are dependent on the deceased person, you can benefit. And that shows that Parliament was alive to the fact that there were some people who were going to get left off and had decided that the only way that they were going to allow those people to benefit was if they were dependent on the deceased. Katrina was not dependent on the deceased. And the CCJ nonetheless decided to lift that ethos in relation to that specific category of people and then apply it broadly to everybody by making that, by changing that definition of spouse in the way that they did. So to me, that is not faithful adherence to the text. It is not in keeping with the judicial restraint that you would want, so that we have a legislature making policy, making hard decisions, because social legislation is always going to they're going to be dividing lines. People are going to get left out. Nothing is perfect. But I don't think that gives judges it doesn't justify judges taking matters into their own hands and then making everything less clear for everybody in the future.
Right. Was the status of the deceased a consideration in that he was still married at the time that he started to cohabit with Katrina? And
so he was. So the problem was that they had been living together, I think it was for 6 years, but for 4 of those years, only for 4 of those years was he a single person, because the divorce didn't come through until they had already been living for 2 years.
Matthew, there currently seems to be a litmus test of wokeness for appointment to the CCJ. Is that a fair comment?
It is a fair comment based on the provisions of the code. And as you aptly summarized, Philippa, the relevant considerations when you look at how they operate in the subsequent provisions of Clause 5 are not irrelevant at all, and do mandate how judges are required to reason through cases, what arguments they will accept as valid or not valid, and indeed provides a filter as who can get onto the court in the first place. Membership of traditional Christian organizations such as the Issachar Foundation would likely exclude an applicant from being considered as a candidate for the CCJ because of our espousement of traditional Christian worldviews. So there is this, for want of a better word, woke, modern, liberal worldview that appears to be a requirement. And it dovetails well with the cases that Alexi explored, because it shows how this broader ideological perspective underpins their judgments, not only on social issues, but matters that really ought to be commercial in consideration, or matters of the organization of family life. It is a pervasive consideration for the judges of the court.
Yes, indeed. Thank you, Matthew. Alexi, back to you. Question coming in. Does it seem that the Katrina ruling may give many women the right to benefit as spouses when the man on whom they've been dependent dies?
Sorry, Philippa, could you say that again?
Right. Does that ruling, the Katrina ruling, give women the right to benefit as spouses when the man on whom they have been dependent on dies? If dependency is the main turning factor.
No, so the act itself allowed for that. There was a provision in the act that even if you had not lived together for 5 years, even if one of you was married, so long as you could prove that you were dependent on the deceased, you would benefit from the estate.
And that's particular to the Barbadian.
That's particular to the Barbados legislation. That was a decision they made to allow that to happen. Yeah.
Okay, great. Now, we've had elections this Wednesday and the incumbent government has been returned, and we know that the JLP was not favorable to joining the CCJ, or they were hesitant or resistant, whereas the PNP, this was a major campaigning point for them. But have either of you heard why the JLP is not so favorable to the CCJ? Have they ever said or given their reason as to why?
I can't recall hearing the party articulate a reason, and commentators who commented on the leadership debate said it was the first time they actually heard the JLP explicitly articulate a preference for a domestic final court of appeal as opposed to the CCJ. So I don't think it is something that has been fully developed in the public discourse.
Okay, thank you. We have a comment here. How can Jamaica adopt the CCJ as its final court of appeal when it is predisposed to legalize same-sex relationships according to the Judicial Code of Conduct? I have a question here. Either of you may take it. Is the CCJ acting as a renegade court seeking to create laws rather than adhering to the text of the law as written, especially when the savings clauses seem redundant? Just trying to wade my way through the legal lingo.
I think how we see the CCJ develop now is probably following some developments in the United States Supreme Court, coming from the days of Chief Justice White, and in the older days of the court, where the court saw itself as a norm-creating body. And if you look to some of the text of those older US Supreme Court decision on abortion, on interracial marriage and gay marriage, they adopt a certain type of reasoning that allowed the engendering of a particular social position, which people now say the Roberts Court, particularly in the last few years, have been trying to correct. It's a competition of worldviews. I think Mr. West put it particularly aptly in his opening statement that we're really dealing with worldviews when we talk about these issues, and what we view the role of the institutions of our society versus what I think the fundamental institutions are, our families and the individual relationships that we have, has in creating normative values. And people, I think the quote from Justice Sumption also addresses the issue aptly, where he says that trying to do through the judicial process what is properly to be accomplished through the political and popular process can result in this feeling that our courts are operating contrary to the democratic will, undermine faith and confidence in the institutions, and really produces the result that we tend to see in the United States Supreme Court now, where less than 40% of people have a positive view on the court. That's because it has gone into the realm of politics, when really by our design of both the constitutional models, it is not to do so. it's a fair warning also to us here to be careful in how we develop our own jurisprudence and how we adopt courts, because we see the end road of that process and it just leads to a lack of credibility in institutions.
Absolutely, definitely. Thank you, Matthew. Could either of you comment on the Privy Council's ruling in Pratt and Morgan vis-a-vis our law on the death penalty? Justice Saunders, previous president of the CCJ, indicated an approach by the Privy Council which went beyond the limits of Jamaican law. Anyone? Anyone?
So I don't know if Matthew wants to take it, but I have not reread Pratt and Morgan since all of this has taken place. But from my memory, I suspect that this is probably true. Because I do think that there was a time when the Privy Council was becoming a little bit activist in how it was dealing with things, and it had a particular view on the death penalty, and therefore, moved things a little bit to get a result that they wanted. But I think that they've learned from that and have definitely stepped it back. We seem to have decided to go the whole hog.
Yeah, precisely. Like Alexia, I haven't read Pratt and Morgan in a very long while, but I do recall the nub of the decision being to take an overly restrictive approach to the language imposing the death penalty such that it is virtually inaccessible as a remedy in criminal cases. And there is a fair criticism of the Privy Council that for a period of time, the judges that compose its panels did have that sort of liberal activist bent. So our presentation does not endorse the Privy Council as a paragon of perfection. All judicial systems are fraught with all the vulnerabilities that any man-made system has. What we can look is with the direction that the weather vane is pointing right now, and we can say comparatively, the Privy Council shows far greater commitment to the fundamental principles of restraint. And we think a lack of commitment to those principles will undermine the value of the institution in the medium to short term, not even the long run.
Right, right.
Yes.
And it's possible that if that case were to be put to this current Privy Council, it might rule differently.
It probably would.
Right. But the question is whether we can see in the CCJ a likely temperament to do that, to pull itself back and to consider differently, or whether no, it's pushing full steam ahead. So the question another question is, how can Caribbean citizens get the worldview of the CCJ to be changed? Is it even possible to achieve this? Can the current worldview be attributed to the type of legal training that these judges received? What can Caribbean citizens do?
Right. Given the code of conduct, I'm not sure.
You would be irrelevant even before you could make a comment.
Well, we can start. Sure, what we could do, but definitely I do think that there does need to be more balance in the legal training and the exposure of law students and judges alike to other views. But yeah, I'm not sure about the CCJ because of the kind of the structure that it has, which kind of sets us out from the beginning. I don't know, Matthew, if you have a...
No, I agree with Alexia entirely, but I draw a lot of examples from what occurs in the United States of America, because we are now at the start of a trajectory downhill that they went on for maybe 40, 60 years. It was similarly the case where the federal courts were staffed by very, very liberal judges, and the Supreme Courts were staffed by liberal judges or conservative judges who became liberal. And what happened in America that has kind of created this shift was a very intentional effort by conservative organizations to, one, establish themselves in schools so that students who come in as conservatives feel free to remain conservatives, express and espouse conservative worldviews. and to provide a network where they could be filtered up through professional training, professional networking, so that they become influential later on. And they are now the candidates that we're seeing on the Supreme Court and on federal courts. So it requires a level of organization among people who hold traditional conservative Judeo-Christian worldviews to say that my perspective on the law and society is valid, it is right, and it is worth putting out in the body politic, and for those views to contend just as well with any other view, and if found favorable, to prevail. So it requires a level of intentional effort. It's not a solution for tomorrow or next year. It requires some patient consideration and the effort taken over time to reap the kind of results that we're seeing in America now.
Right, right. And for whatever we can do at this end, discussion forums such as these is helpful to expose and to help the public be aware of perspectives and approaches so that they can assess for themselves and then to better analyze what they're hearing in the mainstream media. And it might even be useful if you are able to find colleagues in the other territories that do have CCJ as their final court, for example, in Barbados. Are there any Barbados attorneys who are wholly dissatisfied with the CCJ and would want to leave and return to the Privy Council or anything like that? It would be useful to be able to amass comments on those that have that experience of going to the CCJ and compare it to pre-CCJ experiences. Alexi, could I ask you, having appeared before the Privy Council, if you could just speak to some of these comments we usually hear in the media. It's more expensive to go to the Privy Council than the CCJ. Do you have to go to the UK, or can you stay a yard and present and make submissions? These are some of the things. Are there myths? Can you respond to some of these comments that we hear?
Sure. I've never been to the CCJ, so let me start there. But I suspect that some of the expenses of the Privy Council would be similar to the expenses of the CCJ because it's outside of the jurisdiction. So, for instance, just the the level of paperwork and printing and those kinds of things. Although more and more we're doing everything electronically, so that would get rid of the expenses on both sides. Certainly, since COVID, 2 of my Privy Council appearances have been by VideoLink, and so it's not expensive from that point of view. There are no additional charges in terms of your legal fees. So it's really just the fee for the court, and the court does waive that fee for indigent persons. So apart from the actual plane trip, if you were actually going, and the difference between England and Trinidad, I think I would say that would be the major difference. What was the other question? Was there another myth that you mentioned?
Right, I'm coming up with the other one now. It's
Okay.
about the percentage of persons who can access the court. We can access the court being Caribbean citizens, but less so the UK. But I just think if we were really to look at percentages of persons who access the lower courts, and you showed us the diagram, who really goes from the petty courts to your resident magistrates, then to your Supreme Court, then to your Court of Appeal? I mean, what percentage of citizens with a case actually do go to the highest level?
Yeah, it's not a lot.
It's not a lot.
It's not a lot, and I don't know that would change. I mean, there are definitely arguments, and people have made the argument that it would be more if it was a local court. But I don't think we've seen that in relation to even the original jurisdiction of the CCJ. And so I'm not personally convinced. Personally, I would be happy with the Court of Appeal as our final Court of Appeal. Like, if we really wanted to talk about being independent and having our own institutions, just abolish the right to appeal to the Privy Council. I mean, that's one way of achieving it. Commercially, however, I don't think that's the way to go. I think there are advantages to having the Privy Council in terms of our economic structure and our ability to get foreign funds and foreign investment. People like the fact that we have this external court that if they need access to, they can get access to. So those are some things to think about. But I don't think that the average person in Jamaica with a court case intends to take their case that high. And the court, the whole function of apex courts is that they are to be filtering what goes to the top. So just like in the Supreme Court of the US, they're not going to just accept any and every case. It's really cases that have huge public policy implications, or have some relevance across the board. So it's not just your individual spat between two people. It's really a bigger legal concepts that that court is going to be looking at. So I don't necessarily buy that argument.
Okay, great. Okay, just when I thought we were over, we're not. A flurry of questions have come in. Okay, who determines the code of conduct? Can Jamaica insist on a change to the code of conduct as a precondition for joining the CCJ if we choose to go that route?
I think insisting on a change, and whether or not the judges currently and states that govern would agree to it, is a matter of political will. I've not studied the issue, but I'm very doubtful that there is political will to change the court for Jamaica. And it's almost a cynical view, but I think there are some organs in Jamaica who advocate for the CCJ because it has this particular ideological bent. So I think I might even be in the minority in this view. And I did at the Jamaica Bar Association AGM maybe a year or two ago, when a resolution was put on the table by JAMBAR as to whether JAMBAR would advocate for adoption to the CCJ. I raised the concern about its ideology. I brought to the attention of the panel the issues with its code of conduct. And the response from a good many of our colleagues at the bar was, yeah, we like that. We want a court to be activist. That is what we prefer. So it, as I said earlier, comes back down to what Mr. West said at the top. It's a competition of worldviews. And I think that is the battle that must be fought and won.
Right, right. I have our comment. Is it a matter of training or philosophy and political perspective? But I think that probably came in when we were discussing earlier about how is it that the judges have this particular posture. So is it a matter of training or philosophy and political perspective? But I think it would really be philosophy and political perspective, because we've all been exposed to the same training in faculty and law school, but it's how you take your personal spin on it and being influenced by changes that are happening in society, and either deciding to run with that flow as opposed to hold to the law and a faithful interpretation of the law. A question.
But I also think, Philippa, that there is an aspect of training in there.
Okay.
And just like how we've seen in the US, that there's been capture of the educational spaces by the liberal movement. I think that there is a huge liberal component to the professors, and so they're indoctrinating, in a sense, young minds who are already predisposed to being more radical in thinking. And I think that has a part to play as well.
Right. A question: is the CCJ today the same CCJ back when it was launched in 2005 in terms of its approach and its thinking?
That's a great question, and I'm going to commit myself to go read some of the earlier judgments because these are the new judgments. I really couldn't say.
All right. Back to your Katrina Selby case, Alexi. Is the CCJ case definition of spouse applicable in Jamaica, perhaps persuasive though not binding authority, in light of our own legislation defining spouse, death, family maintenance?
Yeah, so I've not yet seen it. I've seen it referenced in Jamaica, but our language is a little different, and our provisions of our Intestates, Estates and Property Charges Act, which is essentially the same, the equivalent legislation for the Succession Act. We don't have some of those really sort of liberal social policy objectives reflected in our act. So I've not yet seen it applied.
All right. Just an addendum here about training. Training is also influenced by funding from external sources. So we know that training of judges.
which may go to this comment that just came in. How do we explain a very liberal Supreme Court in a relatively conservative Caribbean?
There you go. There
I
you go.
think funding does have a lot to do with it.
Yes, yes. Oh boy. Matthew, you're going to have to speak about that, being patriotic and independent. We need to be independent,
Precisely. And
right?
that's precisely our concern. CCJ is heavily funded by EU organizations, and they have criteria for funding. Money does not come without strings attached.
Yes.
So certainly.
Yep, and it goes back to my slide on neocolonialism.
Mhm.
All right, I have a question here now. What might be the goal of the PNP in insisting on government not having a referendum on the CCJ, but accepting it without people's opinions, when we know that the Judicial Code of Conduct may lead to the abolition of the law forbidding buggery? I've had caught a bit of the debates between Mr. Golding and Dr. Holness, and I think Mr. Golding had said that that's what the Constitution allows for, that there's no requirement for referendum. But is there any other reason, if you're aware of, why they are insistent on the CCJ? The PNP, that is.
I don't know that a particular reasoning has been exposed. And I also recall that statement from Mr. Golden. I'm trying to remember IJCHR and Marshall Burnett well enough. And I don't think it's as simple as saying a referendum is not required at all. I think, if I recall correctly, it's a 2004, 2005 PC decision. The court agreed that a referendum is not required for the removal of the CCJ, but
Right.
in order to implement a new court, it needs to be deeply entrenched, and deep entrenchment requires a referendum. So there is still, on this question of what becomes our final court of appeal in the place of the Privy Council, I think it has been conclusively determined that a referendum is required to that extent.
Great, great. Thank you. All right, this is our last question. Is it possible for a country to leave the CCJ having adopted it as final appellate court? Could a Caribbean country divorce the errant CCJ and return to the Privy Council? And what kind of precedent would this set?
Yes, there are provisions to leave the court. I don't know them offhand, but there are such provisions. The question of returning to the Privy Council comes back to whether the Privy Council will have us having left. And I don't think that is very much up to us. So those are the trade-offs that I think exists.
Great. So before I hand
What
over,
we do know though, Philippa, to go back to the whole myth question, is that the Privy Council has repeatedly said, and very recently, that they are very happy to have us, and that they at no point in time have they tried to suggest that they would not like the work that they do for us. So and have been very heavily involved with us in consultation, even as they make changes to that court. So that's another myth that's out there, but it's not true.
Right. Somebody's trying to jump in with a last comment. Say something about the funding of the CCJ. Thought this was secured via trust fund. So it's our governments contribute, but I'm sure Mrs. Richards, who is going to make closing remarks, will refer to where other funding is coming from, which would influence the worldview of the judges. But are you aware if they get funding from other places other than the Caribbean governments?
Definitely, there is EU funding of the CCJ. Trying to bring up a page I was looking at earlier, which spoke to financing agreements signed to support the operation of the CCJ going as far back as 2007 between the CARICOM Secretariat and the CCJ. There's also funding from the European Commission. So there's definitely significant European source of funds flowing into the CCJ as well.
Right. So once we hear funding from the UN, from the EU, from Canada,
yes,
we can, surmise what that worldview influence might be.
Yes.
Well, thank you so much, Alexi and Matthew. I'm going to hand over to Mrs. Richards for closing remarks, but anything you would like to say before we sign off from here today?
Not from my end.
No, thank you very much.
All right. Well, thanks so much for the effort that you have put into preparing this and sharing with us. And we did give you some homework, Alexi and Matthew. So perhaps we might meet you again in a future forum. And thank you so much for your participation today.
You're welcome.
Okay. And I'm now going to hand over to Mrs. Shirley Richards, who was a discussant in part 1 of this expose on CCJ and Privy Council, and she will now bring closing remarks. Mrs. Richards, over to you.
Thank you, Philippa. All protocols observed. What a mouthful this has been. So we have learned that irrelevant considerations, not really irrelevant after all. We have learned that the judges of the CCJ, they seem to have adopted or certainly exhibiting woke liberal worldview. We have learned about ideological hegemony from the code of conduct. We have learned that president, you can be informed by president, but we're yet unburdened, informed yet unburdened by president. All of these things are taken by themselves, taken separately, should ring alarm bells in our minds. Because what do we want of a final court? I am reminded of the words of V.K. Raja. In 2015, he was then Attorney General of Singapore. You know, I'm going to quote it, but why I'm going to quote it is that it's a reminder of the importance of a final court. He said, short of a constitutional amendment, the interpretations that they lay down, which would be the court, are final, and what they hold to be within the domain of the Constitution is thereby removed from the ordinary processes of democracy. So what Mr. Raja was saying is this, that basically there's no appeal from a final court. The only remedy would be for Parliament to pass legislation, and then maybe it goes back through the whole process again. So it's so important for us, this whole question of which court is to be our final court, or which what should be the guiding principles of a final court. Those issues are very important. So Mr. Raja went on to say, underlying the notion of a written law is a belief in the power of the written word, that words have meaning, that words are important, and that words can bind. So one of the things that we are looking for in a final court is a court which will give credence to the text of a constitution or that of any ordinary legislation. So we want to thank, we certainly want to thank Mrs. Robinson and Mr. Royal for their well-presented research today. It was a complex topic which they helped us to navigate. Thanks so much. But again, we say, listen, we are calling for continued critical examination of the judgments of the CCJ. We ask that our concerns, and not just the judgments, but even as Matthew highlighted, including the code of conduct, we ask that our concerns be taken seriously as they are well-founded. We say adopting, when it comes to the final court, it cannot just be about political issues. There are certainly other important issues which need to be taken into consideration. Some of these issues were highlighted today. So again, we're saying to the powers that be and to us all, listen, let's examine this issue critically. It is important to us now and to the future of this country. Thank you very much, Philippa. Back over to you.
Thank you very much for your closing remarks, Mrs. Richards, and thank you everyone who took the time to join with us today. I know it was a rich exchange for you. You've learned a lot and your thinking is being shaped by the perspectives that were shared today. So thank you so much for coming. And just to remind you to visit the Issachar Foundation Jamaica YouTube channel, like, subscribe, and look for the posting of this and previous lectures and also those to come. And if you joined us a little later on and we don't have you on our mailing list, please do post your email address into the chat and I will add it to our mailing list so that you can be informed of our future lectures. Do have a wonderful weekend, everyone, and thank you for coming.